My name's Marissa Allen. I'm a solicitor in the private client team at DMH Stallard.
My name's Catherine Culverhouse and I'm a partner in the Wills, Trust and Estate Disputes team.
We found recently that we're advising blended families more on the preparation of their wills. So that's families where they have children from previous relationships and are now married either with children together or are a blended family. I think there are a number of things to consider when you're preparing a will for a blended family where you've got children from previous relationships. I think the first thing to consider is who you're naming as your executors, making sure that you're naming somebody that can act impartially, that gets on with everybody, and that is going to be able to administer your estate.
Absolutely. It's really important that your executors are aligned, they can act in the interests of all the beneficiaries, and that they aren't kind of skewed towards one particular class of beneficiaries.
And we'll often advise clients that they might want to have a child from each side of the family so that there's each side of the family's interests represented, if you like. But you have to be mindful that that could lead to a deadlock situation.
Yeah, absolutely. I mean, if you're still classing them as one side of the family, then there's likely to be a divide between those two families, even slightly. And therefore that could lead to a dispute in the future where one side of the family believes that an asset or an issue should be decided in that bloodline's side of the family and another in the other.
Absolutely. And that sort of leads on to asset protection. So speaking to your solicitor about having an element of asset protection in your will, whether that's something like a life interest trust, making sure that the surviving spouse is taken care of after first death, but also taking into account any changes that might come in between first and second death, and protecting your respective children and making sure that they're not disinherited in the future.
Absolutely. So it's really important to make sure you do provide for a spouse, and if you fail to do so, then your estate may face a claim under what we call the Inheritance Act, which allows spouses and other certain beneficiaries to make a claim for that provision. But it's also really important to make provision for your children, and if you want that asset to ultimately pass to your children, make sure that those wishes are cemented. I often have people say to me, but they trusted their spouse to do the right thing and give it to their children later on. But relationships change, circumstances change. That spouse could go on to marry again, and then their priorities are altered and they may change their will.
I think alongside that is having very clear written wishes as to why you've made the decisions that you've made within your will. If you are introducing a trust, very clear instructions to your trustees as to how that trust should be administered, what needs to be taken into account, and an explanation to your families so that if a dispute does arise in the future, they know what your wishes were and also your reasons for doing what you've done.
Yeah, and I think that's really helpful as well for your executors to understand what were your intentions, what were you trying to achieve, and whilst those letter of wishes aren't binding on those executors, actually it does give them the context and the wishes to allow them to form their views and to administer the estate in line with that.
Ultimately, you can't prevent a challenge to a will or an against an estate, but you can put in place steps to prevent that challenge from being successful.
Yeah, and that's really important. It is avoiding that dispute rather than putting cast iron assurances in place.
And having the conversations with your family, if it's appropriate to do so, explaining why you've left assets in the way that you have, why you've left more to, say, one child over another, avoids that uncertainty in the future.
Absolutely, and I think having those conversations whilst you're alive allows that backwards and forwards, and that piece around your wishes, rather than leaving it on death when they can't talk to you about it, they can't understand your position.
Ultimately, have a conversation with your solicitor, explain your situation, and draft a will that works best in your circumstances.
Absolutely.